that weirdness blurts out of you before anybody even realizes you were thinking.
You're listening to the Help Me with HIPAA podcast, where HIPAA and humor collide to make learning fun. Your delightful hosts are Donna Grindle and David Sims. Relax. HIPAA help is on the way.
Welcome to the Help Me with HIPAA podcast. My name is David Sims of HIPAA for MSPs, and joining me today, as always, Donna Grindle of HIPAA Compliance. How are you doing today, Donna?
Just Skippy.
Skippy. It's okay.
Yeah, just Skippy.
Just Skippy.
Yeah, whistling, skipping down the road. Got no worries.
All right, well, today we're going to stick your head in the cloud.
That's where I was going.
Which is typically not where it's stuck, but we'll stick it in the cloud today.
Yeah, we know where yours is.
So we had some recent guidance on HIPAA Compliant Cloud stuff. So I'm going to go through that today.
Yeah, it's all exciting. Well, this is something that we've been waiting on a while. And really, the cloud has not been specifically addressed under HIPAA security rules until this, very specific guidance on things in the cloud that I guess they put a lot of words in trying to make sure there was no more ambiguity.
Yeah.
So, it's a lot of that. All you got to do is.
Yeah, the HIPAA easy stuff. Just, do a couple of things. That's all you got to do.
Yeah, and you're HIPAA certified.
Yeah. We'll have a whole show on that one day, I'm sure.
Mm-hmm. Are you HIPAA certified?
It'll end up being just 45 minutes of soapbox rants.
Oh, yeah, that'll be a good one. So the reason that we're happy about this is I can't tell you the number of times that vendors will want us to evaluate stuff. And I say, I think it's a great idea, but you're not meeting this requirement. You're not, you are a business associate. And they will, down to what this word means. What does "the" mean?
Is it "the" or "the"?
The. Are you saying "the"? Are you saying "the"? What was? And, trying to interpret all these things. And, no matter what I said, they were just trying to get me to say that I agreed. And I would say, look, it's your business decision. I don't care. I'm just telling you, if somebody asked me, I would say no. It's their business decision. It's your business decision. If you ask my opinion, I say you're not meeting that obligation. Right. It's my opinion.
Yeah.
So, and people just can't stand that, And I know you're used to hearing my opinion.
I get to hear it a lot.
Yeah. Well, it's not like I don't hear yours. But that weirdness blurts out of you before anybody even realizes you were thinking.
That's not my fault. I don't have that little piece between my brain and my mouth that some people have. This slows things down.
Called a conscious.
Oh, is that what it is?
Mm-hmm. So, anyway, it's time to get our heads in the cloud.
All right.
Yep. Unless we're going to do who's sponsoring today, which we didn't talk about. Oh, yes, we did. There you go. Hit it, brother.
We did?
Your commercial.
My Yeah. You talking about the 15 minutes or less?
Yeah.
Yeah. We'll have to do that some other time. We're not ready for that.
There you go. Yeah, he's not ready. So anyway, it's sponsored by HIPAA Compliance and HIPAA for MSPs.
Absolutely.
We do more than just sit here and talk to each other.
And let you listen.
Uh-huh. And hope you listen. All right, hit it.
All right, so we're going to go through several questions on the cloud computing side of things and look at what the OCR and HHS had to say about it. And fortunately, you have spent lots of time ironing these out into 11 questions that we'll go through. Yeah. Which for those of you who listen, Donna is the one who does all the work around here. I just show up. She'll tell you.
Yeah, you tell it when you tell me I have to do things. So there you go.
I got an idea for you.
Yeah,
which is code word for I got more work for you to do.
Yeah.
So let's look at the first one. May a HIPAA covered entity or business associate use a cloud service to store or process EPHI?
C.
I don't see.
Yes. We know you can use a cloud. However, and they did make it clear, we get another acronym, because we have the MSP, we have the ISP, now we have the CSP.
Yep, cloud service provider.
There you go. So the CSP has to sign, and I thought the way they worded this was very interesting. They have to sign a HIPAA compliant business associate contract or agreement. I know. The agreement includes that the CSP is obligated.
Mm-hmm.
And what the word is.
What does that mean? What does obligated mean?
Does it really mean when it says is obligated? Does it really mean that yes, is obligated to implement the security rule?
Mm-hmm.
The CE or BA should understand the cloud computing environment or solution offered by a particular CSP, so the CE or BA can appropriately conduct its own risk analysis and establish risk management policies. That's really, really important.
Mm-hmm.
You think so, David?
I think that's the same thing that we've talked about for 79 other episodes.
Yeah. Because you've got to know, you've got to evaluate what your risks are when you use this service.
Mm-hmm.
So it says the type of configuration, it affects what your risk analysis and risk management plans, what everybody has to do. So you're supposed to actually understand what you're doing and evaluate your risk of using somebody. So it's why we ask questions of the vendors.
Yeah, and you should. Because a lot of vendors don't even realize that they are dealing with PHI or that they have to be compliant. So you have to ask the right questions.
Yeah, well, some of them don't. I think more and more anybody that's of any size, they now understand it. And it does address a little bit down in a minute, a little bit about the whole what if you didn't know. But anyway, it also says there should be. Now, see, this is not must. There should be an SLA, a service level agreement, that defines the commitments for the service that you're buying, what their features and availability, and particularly it's worried about reliability, availability, where the data centers are, that's an important piece, and what backups are being done. And then it was very, very clear that you can't sign a BAA and then have an SLA that contradicts the BAA by saying, and this is one of those tricks I've seen them do, is to say that the SLA says I can do things that the BAA says I'm not going to do, or vice versa. And then they try to, they basically cancel one out with the other. And it reiterates that the CSP is a BA. Mm-hmm. They have regulatory obligations and they're directly liable if they make uses and disclosures of PHI that are not authorized, required by law, or permitted by the privacy rule.
Right.
Okay, so then you kind of have to know what that is. And if they fail to do the security requirements or let people know when things go horribly awry.
Right.
So, that was kind of interesting. And then it gets to that whole point of what is the actual obligation of a business associate? Well, there you go. They're supposed to know what uses and disclosures are allowed. That's under the privacy rule. Mm-hmm. They're supposed to meet the obligations of the security rule in protecting things, but that involves doing a risk analysis and figuring out what's reasonable and appropriate. Mm-hmm. And then if things go horribly awry, they should notify the necessary people.
So they need to have some indication of what the breach notification rule looks like.
That's right. You kind of need to be prepared for that. And it goes into that a little bit further. So it's saying clearly what we've said that the other rule said all along. But the original final omnibus final rule, 2013, that's more or less what it said, but then it had to go a little bit further in the guidance so that it clarified where people were creating confusion. I don't know that it was confusing because that says exactly what the other said.
Mhm.
I think it's where people created confusion.
Mhm.
So that's
Yeah.
just me.
You are correct. So, number
okay.
2, if a cloud service provider, CSP, stores only encrypted PHI, I like this one, and does not have a decryption key, is it still a HIPAA business associate? Man, I've heard this argument.
A million times.
But let me say it again. If a cloud service provider stores only encrypted PHI and does not have the decryption key, are they still a business associate?
Go ahead. Say it.
Yes, they
They are. That's the one that I get into the most is, it was clear. I mean, I never, took that approach before the final rule, but when I read the final rule, I was a little frustrated by it, but I've had it explained to me in a way that makes sense, and it really helps explain who a business associate is. Because the bottom line is, because you have IT providers that argue that they're not business associates.
Mm-hmm.
Okay, well, here's the bottom line. If that data is not under the control of a covered entity or a business associate, would the services you provide be considered a breach? Whether it's a reportable one or not is irrelevant. Would it be considered a breach? Okay, well, if I give you encrypted data without the key, it's still a breach. I just don't have to report it.
Right.
Well, you can't have PHI sitting in a constant state of breach.
Right.
There you go. That's easy enough.
That's too easy.
I know. Really? It's the IT companies. If we don't look at the EHR, we don't control the EHR. Yes, you control the entire network, all the security on the network, where the traffic goes, how the systems are available, how the systems are configured, and you have administrative level access to all of those things all the time. Do you? Yes. Would that be considered a breach and a hack if you were doing that without them asking you to? Yes. Hello.
Yeah. We battled that with the I don't look at it argument a lot.
Yeah.
So they've already discussed this in numerous occasions, but this is just another time where it's proven that it doesn't matter that you look at it or you can look at it or whatever. You have access to it. You can go in. You could delete the file set or the data set. You could go in. If you got a server sitting in some company cage somewhere, they have access to the cage, or they could destroy the computer physically if they wanted to, which would interrupt the CIA.
Yeah. And that's the whole point. Now they do come up with another term that they identify, and they call it no view.
Okay.
Meaning this kind of case. It's a no view is where I can't really look at it, but I do have it under my control.
Okay.
Which that is it says, for convenience purposes, this guidance uses the term no view services to describe the situation where the CSP maintains encrypted on behalf without the encryption key. So we now have a term to use when we're talking about this. So I am is what you have to get people to say. It's kind of like write this 500 times on the board. I am a no view BAA. I am a no view BA. CSP no view BA. I am a CSP no view BA. Because that's your, eventually it'll sink in. So the no view services, they do say, look, we can say that you can have in your agreement that certain obligations are going to be handled all on one side.
Okay.
So and the example was a perfect one, if a customer implements its own reasonable and appropriate user authentication controls, and agrees that the cloud service provider providing no view services need not implement additional procedures to authenticate the person or entity that wants access, then their obligations are met.
Okay.
So they agree that all of that's going to be handled with the customer. Okay. So the CE or BA who is contracting for the CSP no view services is saying, look, we'll agree that we'll take care of all of the authentication, not you. Well, that's what most of them are going to do anyway. I don't care who the cloud provider is.
Right.
I'm going to give you the capabilities and I'm going to give you the rules, and that's all I can do. An EHR firm or whatever, that's all I can do is give you that, and you have to control it on your end.
Mm-hmm.
That's fair enough. Is to say, and there's a lot of things where you can have flexibility in what they're doing. It's just saying evaluate that and document it. Hello. What a great idea. So that way, everybody's on the same page about who has to do what.
So what about the security rule? Is a cloud service provider in that case still responsible under the security rule for implementing the other stuff?
Well, yeah. I mean, there's some of it that they're not going to be able to not do, which, risk of a malicious actor. Hello. Okay. So risk of a malicious actor having unauthorized access to the system administrative tools.
Mm-hmm.
That's the one, people are like, well, our people, they won't do that. It's not about planning for everything to go right. If we were only planning for everything to go right, we wouldn't have to have HIPAA at all. So we're planning for things to go wrong so that we can prevent that from happening.
Mm-hmm.
So they make that point of you've got to have proper controls in place to make sure people understand what it is they have access to, and that the law says you can only do certain things and you cannot do other things. And then evaluate that, make sure that you're protecting it. You train your staff so they understand. And, things like, obsolete tools and unpatched systems, kind of worry about those.
Yeah, I would say so.
And those, it's the same process of anybody else. So you evaluate all the things, and the customer, the CE or BA who's getting the CSP no view services, they can't control who has access to your administrative tools. They can't control what systems you're using in your security patches and your audits and all of that, and what level tools you use. They can't control any of that. Those are the things you have to control.
Mm-hmm.
So there you go.
Okay. What about the privacy rule side of things?
Well, they did bring that up as well. And they talked about that you have to understand uses and disclosures, even if it's encrypted by there. You mentioned the CIA, the confidentiality, integrity, and availability. They have to ensure all of those things are taking place.
Right.
And that includes some of the things of understanding the uses and disclosures and having a proper business associate agreement in place where needed, and incorporating all of that capability into their systems. But another very important thing, and this is something that they brought up in the security conference as well, is you can't cut off access to PHI. That's not a permissible use of PHI, is to use it as leverage to get payment.
Right.
So you're not allowed to use that data as leverage to get payment.
Right. And I think the example they had used was, I think it was a real world example, but it came into place because a cloud provider wasn't being paid for their services. And so they locked the, I believe it was a hospital, locked them out of their system so they couldn't access anything.
Yeah. So that's a tight place. I don't know how you do that as a cloud provider. It should describe in your agreement what your obligations are, and somehow incorporate that. You can have it all incorporated into one big contract, or you can have it all incorporated into separate amendments and all those different things. That's one thing. It's a whole nother ballgame to have how you're going to ensure you get payment as a provider. I mean, that's a whole new thing for a lot of us to worry about. If they're saying that, and this is a question, we tried to get into it and they really kind of brushed over it. And I really want to ask a lot more questions about this, because look at it from a different perspective. Okay, so we're saying if I have your data, I can't cut you off from it. So you basically never have to pay me for my services.
Yeah.
And I have no way to go. I have to allow you to continue to use the services and try to get the money.
I guess you'd have to try to figure out a way to maybe just have read-only access so they can't really add any more data or edit the data. They can only see the data.
Yeah, but does that meet your obligation? That's the part. I submitted that question, but it didn't land in there where it got out. Would the view-only access solve that problem and allow me still to do that? So that's a question. But now take it a step further, Mr. MSP.
Mm-hmm.
I haven't paid you for months, and then my server goes down.
Yeah, a little difficult.
Uh-huh. Yeah, so but we didn't get to go down that path. So
no, it would be, I guess, what's the terms they use? It would be a I can't remember.
Fact-based determination.
Fact-based determination. There you go. It would be a fact-based determination. The thing about, I guess, that is I'm not controlling their server. I'm just providing IT support. So I don't have any, I'm not blocking them from getting to their stuff.
Well, they might argue that you are because they've contracted with you to keep that server up and running.
Mm-hmm.
And what is in your SLA? Because if your SLA says we're going to respond in X, Y, and Z, but it doesn't say we're not going to do this if you don't pay us, because a lot of people don't put that in their SLA.
Mm-hmm.
And so if your SLA says you're going to do it, what they're saying is you have to keep it available.
Right.
So it is a tricky one, and I think more companies are going to need to figure that one out. And I think that's going to go down. It's one of those where this one little sentence, that's not a use, an acceptable use of PHI is to use it as leverage. That's just not acceptable. So anyway, there you go.
Very good. So how about the breach rule, since we're going down the rules?
Well, and it says the same thing that we've always said is, yes, you have to notify. You must disclose that you have had a problem. No, I didn't know I wasn't supposed to do that, but I'm not going to tell anybody.
So don't ask, don't tell doesn't apply to the breach rule.
No. And it also mentions, important stuff about the fact that, a lot of people say, well, and I've actually had people say, well, I don't have to do anything under the breach rule. Yeah, not so much. You really need to understand it because, yes, you're responsible for notifying the covered entity or the upstream BA, whichever one it is.
Mm-hmm.
But it's still falls, it could potentially come back to you to need to be involved, number one. And number two is you still have a problem. You're going to have to deal, because most business associates have multiple covered entities.
Mm-hmm.
So you're going to have a problem that you need to have a plan for, and the covered entities could come back and say, we want you to address and pay for the breach notification.
Right.
You better have a plan because they are allowed to do that. So, you need to have something, and you must know the strictest requirement in your business associate agreements you signed is the time that you need to have your policy match.
Right.
And people are like, why is that? And I was like, you're going to have 15 different ones.
Mm-hmm.
How you going to know who you got to do? All right.
Number 3. Before you run us off in a ditch. So this one is another one we've argued a lot as well. Not with each other so much with other people, which is, can a cloud service provider be considered to be a conduit and fall under the conduit exception like the Postal Service and therefore not be a business associate and not have to worry about HIPAA?
No. Generally, no. And they said this in the final rule. They said that they reiterated, we expect the conduit exception to be very limited. Right. And everybody wants to fall into that.
Of course we do.
It's transmission only services, whether it's in electronic or paper form.
Mm-hmm.
And it can have very temporary storage of PHI in that process, but it can't ever sit somewhere.
Right.
It's got to be moving. So there you go. Generally, no.
So what about having HIPAA compliant, and I'm doing my little air quotes, HIPAA compliant cloud services?
Yeah. Who are the HIPAA compliant? Which CSPs are HIPAA compliant? And I love that reiteration of what we talk about, certified HIPAA compliance. What was it you said? Somebody called and said, after I do your classes, will you certify that I'm HIPAA compliant?
Right.
And what did you say?
No.
No, really.
And then, of course, I went on to say, sure, I could say you're HIPAA compliant, but you could too.
I could just today make a little I'm HIPAA compliant, HIPAA certified, whatever, and slap it up make it look all official and put it on my website and all my documents.
And there are people that do. If you're listening and you're one of those, shame.
Shame. Well, it's misleading. And this is one of those things where, I question how much, because the FTC is starting to really get involved in some of this. And you mentioned that when we were talking about it last time, is how much will they allow that to happen without saying, hey, that's misleading advertising, that's going outside the realm of what we allow businesses to do. But the point and the answer to question number 4, very succinct, single sentence.
No.
It just
OCR does not endorse it, period.
Yeah, OCR does not endorse, certify, or recommend specific technology or products, period. That's it. It's done. Well, if the people who are responsible for determining whether or not you meet your compliance obligations won't endorse, certify, or recommend anything, how can anybody else say that they are? Yeah. That's what our problem is with that.
Yeah. So. And it's everywhere. We see it everywhere. HIPAA compliant this, HIPAA compliant that.
Certified HIPAA compliant. You can't, if anybody says you're certified HIPAA compliant, you have to say by who or whom. I don't know which one it is.
It doesn't really matter at that point, does it?
Yeah, but you have to ask, who said that? Did you go through a class and have to take a test? Okay, well, that's great because I get that, and that's a good thing. That's not a bad thing. But I want to know who gave you the class. Was it a 15-minute class and a 5-minute test, or did it take longer than that? Because if it took longer than that, then it really means something. But if it didn't, or I simply bought your services and that made me HIPAA compliant,
Yeah.
If you just buy our services or become an affiliate with us, then you're certified HIPAA compliant. You can put it on all your stuff. There's people that do that. We know about it. And it's misleading, and I don't know how it's going to happen, but, it's just like people who say our clients have already passed the audits, but nobody's heard back from their audits. How can you say that? We've passed a random audit. How?
None of my clients have ever been fined by OCR.
Yeah, I can say that.
Me too.
But it doesn't mean that it's because of anything I did. But anyway, that's, but you and I have very passionate feelings about that. And that's because in the end, I'm still worried about protecting patient information and the patients and the businesses and how they can be affected when these things go wrong.
Yeah. We're not looking at it from a marketing sales standpoint, which I think a lot of people that spew that mess all over the internet, that's what they're doing. They're just trying to sell a widget or a service or a software or whatever, and that's just one way they do it. But unfortunately, it muddies the water so bad that then you start to defend why you won't go down that path. So anyway, we'll move on. So number 5, what I know we could do a whole show on that.
Yeah.
What if a HIPAA covered entity or business associate uses a cloud service provider to maintain EPHI without first executing a business associate agreement with that cloud service provider?
Well, then, now this one, this is one that
cart before the horse, chicken and egg.
There you go. Well, this is one, when I pointed this out to people and I said, look, you need to understand that if you do that, it's 2 HIPAA violations every day. Every day that you're in that situation, it's 2. There's, one is that you don't have an agreement and you're allowing them to do the service. And 2 is they have the data. So it's an improper, unauthorized disclosure. So you got both of those happening every day. And That's just, just because of that. And who knows what else is going wrong if you don't have a BAA. That's all I'm saying.
That's all you're saying?
That's all I'm saying. But so that is a bad thing. And I don't care whether it's cloud service provider or an accounting firm, anybody, an analysis firm, you've got to make sure that and I'm not saying every case there are a BA. You shouldn't just give everybody a BAA. Don't do that. That's even worse.
Yeah.
Because now that's clear that you're not paying attention to any of them. So, you need to determine in each case, what service or product am I buying? Does it require me to have a business associate agreement? That should be step one in the sales process or the purchasing process if you are a covered entity or business associate. But I did see something new and interesting that I hadn't seen before in the guidance, particularly on this. It says they will provide an affirmative defense option in cases where a CSP takes action to correct any noncompliance within 30 days or such period as OCR may determine appropriate based on the nature and extent of the noncompliance. So they do give themselves a little caveat there.
Mm-hmm.
If you could have done that in 10 days and you're telling me in 90 days you still haven't done it, But it's with that time frame is that number of days from the time that they knew or should have known that they were in violation.
Okay.
So, they've gotten rid of the affirmative defense for, used to. That was why you couldn't really enforce HIPAA. It was voluntary. There was very little enforcement built into it. There was no definition of it. And you always had the affirmative defense. My bad. But it makes it clear that you can't claim that, that it will not apply where the CSP was not aware of the violation due to its own willful neglect.
Okay.
So if you're just absolutely not even looking into it and you don't even consider that if, you're going to go for affirmative defense and don't let me know, just don't tell me what you did last weekend. And then I'll say I didn't know.
I can either confirm or deny the breach.
That's right. So that was, it's a pretty cool thing. And it does give them a little bit of an out because a lot of people said, so because the rule says it's the action you perform makes you the business associate, not the BAA.
Right.
So you're obligated just by doing the action. And if you don't even know you're doing the action, we'll give you a little bit of a break.
Mm-hmm. And that's the same argument we've had with IT providers that some people are like, oh, well, you don't need to worry about it. Just don't sign anything and you won't have to worry about being a business associate because you didn't sign the paperwork. Nah.
Yeah.
Which brings us to number 6.
Yes.
If a cloud service provider experiences a security incident involving HIPAA covered entities or business associates PHI, must it report the incident to the covered entity or business associate?
Sí. Sí, señor. Yes.
Yeah, and that's nothing new. I mean, why wouldn't you?
Yeah.
That's just good business practice. It doesn't matter about HIPAA. It's just good business.
Well, and it makes the point, the breach notification rule, it does say what what you have to have in the content and the time and other kinds of things that, because the business associate is supposed to do everything they can to identify what happened and who the patients were and all that kind of stuff, because that's what the CE or the upstream folks are going to need. So they do need to do that to the best of their ability, we'll say. Mm-hmm. But it's okay that the BAA may be more stringent. As long as it doesn't violate the requirements of the breach notification rule, the BAA can say any other stringent requirements. So it can say 5 days. You got 5 days. Give me everything you got. And a lot of people, most people do that. They don't give you 60 days. Mm-hmm. Because what if I give you 60 days to tell me, and then, 30 days into it, it hits the news and I'm blindsided? Right. I don't want to give you time to ruin my business. So there you go.
So the next one is kind of parallels with some mobile device stuff, and we often get asked that. Mm-hmm. But does HIPAA allow healthcare providers to use mobile devices to access EPHI in the cloud.
C.
All right, we're just going to have a Spanish episode today.
Well, that's good. You started it and earlier. So anyway, yes, because it doesn't say what you can and cannot do, but
You have to plan for it.
everybody
Do your
knows
risk-
about the but.
Yeah.
You've got to do your risk analysis. You've got to make sure that the utilization and what you plan on doing and the mobile devices and all of that is properly secured.
Mm-hmm.
So, you can't say, oh, you're not allowed to use it, or you can use it. Don't worry about it. Just grab it and go. You've actually got to sit down and make some decisions. That's all it's about, is making decisions and making sure you're meeting your obligations to secure the information even on a mobile device.
That's exactly what we said on a mobile device episode.
I'm pretty sure.
So number 8, do the HIPAA rules require a cloud service provider to maintain EPHI for some period of time beyond when it has finished providing services to a covered entity or business associate?
Well, yeah, they don't make them do it. However, but
Lots of big butts here.
but the business associate agreement requires you to either return or destroy or certify those kind of things. And if you can't return it or destroy it, then you're obligated to protect it until you can.
Mm-hmm.
But that should be in your business associate agreement. That is, the caveat there is, have you been able to maintain it? So in those cases where you have somebody that hires this company to do the backup for them, say, and it's, an encrypted thing, if their business associate agreement says that you have to make sure I get my information back, then they just do all of the paperwork and they make sure that that's done, and then they can whack it. They don't have to keep it any longer as long as they've met the obligation under the business associate agreement.
Okay.
But
Easy
they do
enough.
need to keep their HIPAA documentation for 6 years.
Good point. Glad you brought that up. So number 9, do the HIPAA rules allow covered entity or business associate to use a cloud service provider that stores EPHI on servers outside of the United States? We talked about this a little bit last week.
Yeah, and that was one where we had gotten that question from Kevin, I think. So, this is a tricky one. I have a friend who is a healthcare attorney who was saying that in all of their business associate agreements, they don't want to ever be limited. Now, they represent hospitals and big entities and stuff. They never want to have a limitation on where the server can be. So they don't want to ever be told we can't put data outside the United States on a server. And I'm like, that would nut me up. and he's like, yeah, but I'm going to tell you, I don't want that in the agreement. But the bottom line is, if you're going to do that, then you have to do a risk analysis and make sure that your business associate agreement properly states that that's what you're going to do. And you need to understand the laws and all of those capabilities, because if it's in another country that takes 30 years to go to court and anything you win, you can't leave the country with, boom.
Not going to happen.
Mm-hmm. So that's why you have to be careful about it.
All right. Brings us to number 10. Do the HIPAA rules require cloud service providers that are business associates to provide documentation to allow for auditing of security practices by their customers who are covered entities or business associates?
No. However, no, but the HIPAA rule does not require it.
Mm-hmm.
It does require they obtain satisfactory assurances in the form of a business associate agreement. However, the covered entities and business associates can require additional assurances of the protections of the PHI, documentation, safeguards, audits, in doing their own risk analysis and risk management and their own compliance activities. They can ask you to do this. So it's part of them doing their proper due diligence on securing their information by asking you about it. HIPAA doesn't say that I have to ask you about it. It just says I have to have a contract with you. And we've talked about that a great deal, about the importance of actually doing a bit of due diligence so that you can understand your risk, because so many cases, that's just, they sign the BAA and then they're not actually doing the things to protect the information.
Mm-hmm.
And then you have to decide whether or not that's okay. I don't care. It's your business decision.
You have to make an informed decision yourself.
Yeah, it's a fact-specific decision.
Determination.
Yeah, there you go.
We love that clause.
Fact-specific. Everything is. That's why you can't do HIPAA easy.
Oh, man. So the last one, number 11, if a cloud service provider receives and maintains only information that has been de-identified in accordance with the HIPAA privacy rule, is it still a business associate?
No. No one is. If they have proper de-identified data, then the de-identification is a specific definition within the privacy rule that says if you've removed all these things, it's no longer PHI. And if I don't have PHI, I don't
have HIPAA.
I don't have HIPAA. So there you go.
All right.
It's just the definition of what is PHI. And if I don't have it, I don't have it.
So you're going to provide a link in the show notes on the website for all this stuff?
Of course.
Very good.
Yes, I will do so. I will include a link of guidance from HHS and of course our little show notes on what we thought.
Our HIPAA certified show notes. So that's our show for today, folks. Thank you for listening. If you'd like to sponsor our podcast, we are accepting some applications for sponsorship. So remember that. You can review us on iTunes, share us out on your favorite social media channels, and you can visit us on the web at helpmewithhipaa.com. And you can ask a question right there on the front page, and we may feature it in a future episode. Anything else, Donna?
No, I'm good.
All right. Well, I'm going to spend the next 30 minutes pulling you out of the clouds. So just remember, HIPAA is not about compliance. It's about patient care.
You've been listening to the Help Me with HIPAA podcast, hosted by Donna Grindle and David Sims. The show created to help you with HIPAA. For more information or to ask us a question, visit our website at helpmewithhipaa.com. Neither Donna Grindle or David Sims are attorneys, and they do not offer binding legal advice concerning regulatory compliance. The information in this podcast should not be relied upon or construed as legal advice in any way. Consult your attorney for legal advice concerning compliance with HIPAA regulations.